Hello everyone and welcome to today's Mondat webinar in association with Blank Rome, who will explore high-profile anticipated rulings that could change the landscape of litigation and the resolution of mass claims. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Roy Arnold serves as co-chair of the Blank Rome's National Class Action Defence Team and as co-chair of the firm's Pittsburgh office. He has over 30 years of broad experience representing clients faced with alleged class actions, shareholder derivative lawsuits, and other complex commercial litigation. As a result of his diverse experience, Roy has defended more than 300 putative class actions in various state and federal courts throughout the United States. Deborah Greenspan is the co-chair of the Environment, Energy and Mass Torts Practice Group at Blank Rome. She is a leading advisor on mass claim strategy and resolution. Her practice focuses on class actions, mass claims, dispute resolution and settlement negotiation and design, insurance recovery and mass tort bankruptcy. She has extensive experience in mass products, liability matters, class actions, analysis of damages and future liability exposure, insurance recovery, alternative dispute resolution, claims evaluation and dispute analysis, settlement, distribution, design and implementation, claims management and risk analysis. She's been involved in some of the largest mass tort MDL and bankruptcy cases and currently serves as a court-appointed neutral in the Flint water litigation in Michigan. David Moulton is a partner at Brown Rudnick's Litigation and Arbitration and Bankruptcy and Corporate Restructuring Practice Groups and is a co-chair of cross-border mass tort and restructuring litigation. David focuses his practice in complex financial, commercial and mass tort litigation matters in federal, state and bankruptcy courts in the United States, and he represents foreign liquidators, official committees of creditors, unofficial ad hoc committees of creditors and interested parties in financial fraud and mass tort related litigations and bankruptcies in the United States and in foreign jurisdictions. And completing our panel is Edward Niger. Edward is currently co-managing partner of Ars LLP, one of the leading mass tort, sexual abuse and bankruptcy law firms in the country, with client recoveries and settlements totaling more than $500 million. Ed is one of the few nationally recognized leaders in both bankruptcy and mass tort law. Now, before I hand over to the panel to begin today's webinar, a housekeeping item, you can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage you to send those questions in. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thank you, Dan. We are all delighted to be here today. I'm going to give just a quick overview of the scope of this webinar, and then we'll dive right into the substance. We're going to be focusing on the different legal vehicles that are used in the United States to address what we're calling mass claims, people often think mostly of mass torts, but there are other types of claims that can be addressed in large quantities. Each of these different legal vehicles has its own rules, its own limitations, options, opportunities, and scope. And in this webinar, we will address the class action device, mass consolidations, primarily focusing on multi-district litigation, and bankruptcy. Just to set the stage a little bit, for many years, class actions were the vehicle of choice to resolve mass claims, but various judicial decisions have affected the use of the class device, at least in some circumstances. Multi-district litigation and mass consolidations arose as an alternative structural way to address mass claims, but with certain other limitations. And in the past several years, the bankruptcy device has been used or is attempted to be used to resolve mass claims, which generates different debates about the scope of the claims that can be resolved and the policies regarding the entities that should and can benefit from the type of release you achieve in a bankruptcy case. So to start us off, I think, Roy, can you help us and explain, just set the stage and explain the class action device briefly for our audience?
Thank you, Deborah. In simplest terms, the class action device or vehicle, as Deborah called it, is a procedural device in federal and state courts in the United States. that enables one or a few plaintiffs or claimants who are bringing certain claims to represent and assert the claims not only on their own individual behalf, but on behalf of a group of similarly situated other claimants who also possess the claim. There are procedural rules in our federal courts in the United States. It's Federal Rule of Civil Procedure 23, and then there are state rules of civil procedure or statutes that are similar. Some of them are similar to Rule 23, and some are different. And the rule has very specific prerequisites. Rule 23A, there's requirements of numerosity, meaning typically that there's more than 40 claimants in the putative class or alleged class. There are common issues of fact or law. There's claims are typical between the named plaintiff and class members, that the named plaintiff and his or her counsel would be adequate representatives, and then ultimately that one of Rule 23B, if we're talking about federal court, one of the 23B requirements is also satisfied. And when we're talking about the types of claims that are being discussed today, I think the panelists are primarily would be talking about Rule 23B3 type class actions where there are claims for monetary or compensatory damages or statutory damages. And that requirement also requires a showing that there's common issues that predominate rather than individual issues, and then that the class action device is superior over other means of litigation, primarily individual lawsuits. And so it's important to envision this as a procedural vehicle in litigation, and it is one of the ways that we're going to talk about today that claims can go from, they can be relatively small claims, but when they're aggregated in a class action, they can be very sizable claims. They can run the gamut up to several $1 million to tens of millions of dollars, to hundreds of millions of dollars, to some class action claims can involve billions of dollars of claims. So that's a little bit of an overview about class actions. The key in understanding class actions and really the points of time in the litigation that are critical, there's typically challenges at the pleading stage. There may be summary judgment motions filed, but the many times we view the quote money issue is really the fight about whether or not the case that is filed as an alleged class action will be certified as a class action. And that is done by the court and with input from the parties and based on a record that the parties developed for the court to address whether or not the prerequisites of the class action have been satisfied.
Thank you. I'm going to just give a quick overview of what we're calling here multi-district litigation. And I want to mention that everything we're going to talk about here in this particular context really applies to any sort of mass consolidation. But we've picked multi-district litigation as a focus simply because it's so prevalent in the United States federal courts. Statistic I saw recently says that over 70% of the cases filed in the federal court system in the United States are in a multi-district litigation. And what that means is that there are cases that are filed in various federal courts around the country that raise similar issues. And then there is an application, or some party will make an application to the judicial panel on multi-district litigation, which is composed of a number of different judges from different parts of the country. And they're asked to determine whether these cases can in fact be consolidated in a multi-district litigation. And if they agree and determine that they should be, all of those federal court cases are then transferred to a single jurisdiction, a single selected judge to handle that multi-district litigation on a pretrial basis. So the point is that these claims are all consolidated. You then have them in one place. You can start conducting discovery in a more efficient way. and get a handle on what these cases are and what the legal issues are. It becomes something of an alternative to the class device because it doesn't require some of the findings and determinations that a class action requires under the rules that Roy just mentioned. And it also has more flexibility when it comes to personal injury type claims that might be asserted. With class device has some limitations on that we can get into later. I think at this point, before we even touch the bankruptcy issue, I think it might be helpful to put up our first poll. I should have mentioned earlier, we have 3 polls that we'd like to take and see what the audience thinks about them, and then we'll continue. We'll just be very interested in what you have to say. So I'd like to hand it over now to David and Ed to talk about bankruptcy, which is perhaps the most complicated of these 3 vehicles that we're talking about today.
Thank you, everybody. It's a pleasure being here and an honor speaking with such a panel. Just as a general overview, bankruptcy, which is referred to in Article 1 of the Constitution and is one of the powers that is given to the federal government to enact legislation for, provides for debtors. We use the term debtors. Those debtors are often mass tort defendants. You know, the argument is that the debtor needs to be deserving of bankruptcy, needs to be in financial distress, or and that's a present issue that's being litigated. But what bankruptcy offers in its truest sense and most simplest sense is a way for a debtor defendant to who's facing overwhelming mass tort liability to aggregate and consolidate all of the claims against it in a single court, the bankruptcy court, and what the term is, fairly and equitably resolve those claims in the bankruptcy, often consensually, sometimes contentiously, but most often than not involving payments or distributions which are less than full pay, basically pro rata payments. And we call bankruptcy a collective proceeding because each creditor, claimant, tort claimant has a right to its pro rata proportionate share of the aggregate value, the estate of the debtor. Now, if it were just the debtor resolving its tort liabilities in a bankruptcy, probably we wouldn't have all the controversy that you've been reading about in the New York Times and Wall Street Journal and on the legal wires. But the issue gets juicy because there are third parties. And it's the issue of third party liability, whether the third parties are directors and officers, whether the third parties are affiliates, parents, successors, predecessors, or independent entities, all of whom can be named under applicable law as co-defendants with the debtor in the underlying tort claim. For example, a manufacturer debtor will often be named with its distributors, marketers, and retailers, all of whom are not the bankrupt party, or officers and directors, or parents. And we know, from recent history, one of the examples is a parent, Johnson & Johnson, put one of its affiliates, a company called LTL, which stands for Legacy Tort Talc Liability, into bankruptcy. And the goal on these cases is to try and to resolve not only the claims of the debtor, but the claims of the third parties. And that's where the rubber hits the road and we get a lot of the interesting issues that we're going to talk about later. And the reason that the bankruptcy courts have jurisdiction, so to say, over these non-debtors, at least reading through the various circuit and Supreme Court case law, is if there's a connection between the claim against the non-debtor and the debtor. For example, claiming against a retailer will create an indemnification claim that the retailer has against the debtor. So every dollar you get outside of the bankruptcy against the retailer creates a dollar claim against the debtor in the bankruptcy. And we, again, this is a long road and really a rabbit's hole we can go down. I'm not going to do it, but I just wanted to give you a little bit of the overview of what bankruptcy is and where the issues come up. Edward.
Well, I think I may go down that rabbit hole, but first I want to explain in very simple terms when a mass tort MDL is appropriate and when a class action is appropriate. A class action is a situation where the injury to everyone was very similar. And in that case, you have one plaintiff suing on behalf of a class. In an MDL type situation, the tortfeasor committed one harm or a similar harm against everyone, but the damages to everyone is different. So say, for example, in the PG&E wildfire case, some people died, unfortunately. Some people's houses were burned. Some people's businesses were ruined. In those cases, a class action is not appropriate, and everyone has to file an individual lawsuit, which is then often consolidated into an MDL. I can also touch upon some consolidations where there is no MDL. For example, in the Hawaii wildfire cases, about 100 lawsuits were already filed, and now there's two movements for consolidation. One is a consolidation within the state court, and then the other one is a removal of the state court actions to federal court. So there's also consolidations in the non-MDL context. Now, moving on to bankruptcy, I think that what David said about the third parties who put in money to plans and get releases, at least until June of 2024, that is the primary advantage of resolving cases through bankruptcy over resolving them through an MDL, right? The question is, why should you try to resolve something in bankruptcy when you could resolve it through an MDL? And I think the answer is that in a bankruptcy situation, at least in the asbestos case, the bankruptcy code explicitly allows it, and that is third parties can put in money into the bankruptcy and pay creditors, and those third parties will get what's called a non-consensual release. The reason it's not consensual is because not everyone would consent to it. Some people voted no on the plan, and some people weren't involved in the bankruptcy. Bankruptcy courts have adopted that strategy in non-asbestos situations, and I can tell you that in almost every large bankruptcy, that was the way creditors got paid a lot more than they would have gotten paid in an MDL situation. For example, in PG&E, there was a $12 billion settlement. A lot of that money did not come from the debtor, they came from third parties. Those third parties got non-consensual third-party releases. In the Boy Scout situation, the Boy Scouts were only worth about $250 million, but the settlement that the creditors, the victims who were sexually abused when they were scouts at the Boy Scouts, are getting approximately $2.5 billion. Well, how are they getting $2.5 billion if the Boy Scouts are only worth $250 million? The answer is the money came from local councils, insurance companies, religious organizations that were affiliated with the Boy Scouts that wanted releases from liability. They put in over $2 billion, and that money will go to the victims. That is not something that can happen in an MDL. It can happen in bankruptcy because under bankruptcy law, at least as it currently is, most circuits hold that if you put in money, you can get non-consensual third-party releases. In the Purdue bankruptcy, for example, Purdue is only worth about $1 billion, but there is a $6 billion settlement where most of the $6 billion will go to states to abate the opioid crisis. $750 million will go to victims, many of whom I represent. all that money is coming from the Sackler family, even though the Sacklers themselves did not file for bankruptcy. So you went from a company that is worth $1 billion to victims getting a recovery of $6 billion. That is a primary advantage of bankruptcy that cannot be done outside of bankruptcy. Now, there's a question as to whether that actually can be done in bankruptcy. Asbestos, we know it could be done in bankruptcy because the bankruptcy code specifically allows it. The non-asbestos scenario, the 30-year precedent, at least in the Second Circuit, was that it could be done. The DOJ is appealing that. That is currently pending before the Supreme Court. Oral argument was December 4th. The Supreme Court will probably rule in June, and we'll find out whether this primary advantage of bankruptcy, where other parties can put in money and creditors can get meaningful recovery, where those parties will get non-consensual third-party releases, we'll find out if that will continue. Just a little tidbit, I'm giving you the latest update. Some of the appealing parties in Boy Scouts actually just, I think yesterday, filed a petition for, I'm sorry, David?
State petition.
They filed a state petition to Justice Alito to stay the Boy Scout settlement because it involved third-party releases, pending the resolution of the Purdue bankruptcy.
Yeah,
And we'll
so
see
we're gonna get into the Purdue case in more depth, I think. Ed, you guys are given a great teaser to further discussion. So I wonder if we could go back to the class action issue, and we're gonna go through class action and consolidations a little bit more and then get back into this discussion, which is really, I think, the hot topic of the day. Ed, you painted a great picture of a win-win situation in the bankruptcy.
I'm very excited about it. I jumped the gun. I'm sorry.
No. So let's go back to the class device, because it's certainly used in many situations where we have mass claims. And I think we're going to go through a few of the issues that are out there, or newer kinds of uses of the class device. I'm going to spend just a moment noting for everybody. I think Roy has given us the overview of what the rules are and how you actually obtain class treatment. What is beneficial for if you're a defendant, really, if you are able to resolve a class case, let's say you have a class settlement, the benefit there is that you get a release, a class release of everybody in the class who's defined as a member of the class, and you get a release whether or not the person actually comes forward and makes a claim or asserts anything in a settlement. The only people who are not released in a class resolution are those who opt out of the class. I think Roy mentioned earlier that Rule 23B3 is an opt-out class. There are other types of classes. We're not going to get into those today. So there is a distinct difference really in the case law between litigation classes and settlement classes. Some of the manageability issues that appear in a litigation class are not so important when the class is settled, and therefore it allows some flexibility in the types of claims that can be addressed through a class device. But there are other issues coming up in the class arena, and I thought, Roy, if we could talk perhaps for a moment about some of those. For example, the issues class component that is relatively newer in Rule 23 and what its use might be.
Sure, and just to set the table, so to speak, the issues class arises because Federal Rule of Civil Procedure 23C4 explicitly or expressly provides that, quote, when appropriate, an action may be brought or maintained as a class action with respect to particular issues. And the debate that has occurred over recent years that culminated in a petition for certiorari to the United States Supreme Court in a case called Bear Dayton Thermal Products versus Martin. Ultimately, the Supreme Court denied certiorari but there was a circuit split, and the issue really turns on whether or not you can have a class certified with respect to particular issues, even though perhaps the record or the moving party, the plaintiff typically, has not been able to establish that the predominance and superiority requirements of Rule 23b3 are satisfied. And so the Ninth and the Second Circuit had basically held you could have issue only class certification, the Seventh Circuit and the Fifth Circuit. And these are, when I refer to these circuits, these are courts of appeals for the Second Circuit, which involves several federal districts. For example, New York is a part of the Second Circuit. The Ninth Circuit includes California. But the Seventh and Fifth Circuit, they basically said you had to establish that essentially that you met the requirements of a 23B class, typically 23B3, and met all of the prerequisites or requirements of that. The Ninth and the Second Circuit recognized certification of just issues only. And the debate really is when you're defending class claims or class actions, and you're battling against the class certification effort, you want to demonstrate that there are these individual issues, and Ed alluded to them when he was making remarks, that whether it's differing damages or really the elements of the claim require individualized proof and different evidence, that there isn't this common class-wide evidence that proves the claim. And so when you talk about having an issue class certified, from the defense perspective, it's something that we would fight vigorously against on the ordinary or routine type class case, because you'd want the plaintiff to have to establish all of the prerequisites of class certification and not simply one part of the claim. Our arguments would often be that, well, you might have the issue addressed, but you have other issues that are not being certified, and that they would devolve into numerous individual issues. So that issue comes to the forefront periodically, and as Deborah said, there can be resurgences of the issue class periodically, and it really can be driven by the plaintiff's bar, I would say, more than the defense bar, but others may have views.
Okay, thank you, Roy. I actually am currently involved in a case that has an issues class, which was just recently the subject of a resolution, but the split was liability versus damages. So damages were not certified, but the liability issues were. And the theory that otherwise you have to relitigate the same facts over and over again in thousands of cases. But let's because we want to move on to some of the other topics we have a lot to cover. Are there particular things that you think are going on in the class action world that people should look out for in 2024? Are there things on the table there that we want to pay attention to?
Sure. Well, as you might expect, I follow class action filings pretty closely across the country on a daily basis. And what we're seeing is we see a tremendous amount of data privacy and data security class actions being filed. Those can involve data security breaches, your traditional somebody hacks a system or there's a breach of the data security. We're seeing a tremendous uptick in what are called biometric privacy cases. There are these state statutes that have been enacted in various states. Illinois is a good example, where there have been some court rulings that have dramatically escalated the potential exposure on some of those types of claims. But frankly, you see pretty consistently, you see a bit of an uptick in some antitrust class actions being filed. virtually any consumer business with a market in the United States. You could face consumer class actions, whether it's a product, whether it's a financial services company. They're in the employment side. There are these collective and class actions for wage and hour issues. Any type of life insurance, property casualty, life insurance, you see class actions being filed at a regular basis. And food and beverage, labeling and mislabeling, those are areas that are very common. And currently, we don't see as many securities class actions, but you see shareholder derivative actions, challenging board actions, and particularly if there are sort of crises facing companies, increasingly you're seeing some derivative actions being pursued, perhaps in the Delaware Court of Chancery. But the areas that we see that are the biggest uptick right now really are those privacy, data security breach, biometric, and a few other ancillary topics like wage and hour, because they're just so prevalent in terms of the cases being filed.
So I'd like to just make one comment about mass arbitration and then move on. We mentioned this in our outline. It's not a class action. This is something that has arisen as a result of arbitration clauses that you often find in consumer products. When you buy something online, you are probably clicking on an agreement to arbitrate any dispute that you might have. And also in the employment sector, there obviously are arbitration clauses if there's employment disputes. What has occurred is that as a result of multiple decisions in the U.S. Supreme Court, in many circumstances, you cannot pursue arbitration on a class basis. There were efforts to kind of consolidate similar claims into a class type action, but in an arbitration instead of court. And so what that has created is a need to file individual arbitrations when there is a dispute. And what has occurred in the very recent several years is that multiple individual, thousands and thousands of individual arbitrations are being filed for particular disputes, resulting in significant fees for the defendant in these arbitrations to pay in order to pursue the arbitration, because in the arbitration agreements, they usually say that they will pay the arbitration costs. These fees can range, they can be 8-figure fees. They're tens of millions of dollars in some cases. And so now there is just to give a preview, there is a move afoot among the various arbitration providers that provide arbitration services to alter their rules to really react to this situation. And I just mention it because it has become a very common situation, and it is also another form of a mass claim process. So we should move on to the next topic, which is the consolidation topic. And I think this one will be fairly brief. We want to get into our bankruptcy discussion. So if we could move to the next slide. Again, we mentioned earlier that we're focused a bit on multi-district litigation just because it is so common in the federal court system. But of course, consolidations can occur in the state courts, in cases that really arise in a given jurisdiction that are not actually implicating multiple different jurisdictional issues. Multi-district litigation is a tool, really. It's a way in which to provide a more efficient and consolidated pretrial process. Discovery you don't have to take the deposition of the same person 25 times. You can do it once in the multi-district litigation context, and so things become more efficient. It also has become a way in which claims can be consolidated so that they can be evaluated and then perhaps resolved in some consensual manner. There may be a process for compiling data about claims, sometimes called a census of claims, so that everybody has information and can better address the various and claims in the aggregate and individually. There may be bellwether trials or other procedures to try to evaluate and put and determine really the viability of the claims. So all of those things can happen in a multi-district litigation case or in some other consolidation. And I should note one limitation to the formal MDL process that we're talking about here is that it only applies to federal court cases. So state cases are not included in this process. Often the states will consolidate cases separately and perhaps even cooperate with have a cooperative procedure for conducting discovery. But these multi-district litigations sometimes evolve into class actions or evolve into bankruptcy. Just a very quick example is there is a multi-district litigation involving PFAS, PFAS, which is a chemical that, or a product really that is ubiquitous and is used in many different ways. And in that multi-district litigation, there are two proposed class settlements involving municipal water entities that are faced with the prospect of trying to detect and remove or clean or otherwise account for these chemicals in the water systems. So the multi-district litigation device was the starting point. The class action was created for settlement purposes. We talked earlier about the difference between settlement and litigation classes. And then sometimes MDLs move into the bankruptcy arena. So I think that this will be a quick segue into our bankruptcy discussion, which involves so many interesting topics, as you've already heard. So I think we've already had an overview of some of what is going on, but perhaps to set the stage for everyone, could Ed or David, could you spend just a moment explaining how it actually works? You sort of have this bankruptcy case filed, you have proofs of claim in some cases. There's a procedure that one goes through in a bankruptcy case. Perhaps give a bit of an overview of that, and I'll ask that the next slide be.
Ed, do you want to take a shot?
Happy to. So what happens is a defendant, whether it's J&J or 3M or Aero or Boy Scouts or PG&E, gets faced with mass amounts of lawsuits. Some are into MDL, some are not. A lot of times they end up defending cases all across the country, and it's highly, highly inefficient. Another problem is that they're so busy dealing with all these cases that they can't focus on the actual business. And the actual business is usually the asset that the creditors want. So for efficiency purposes, they file for bankruptcy. And what happens is, in the bankruptcy, as soon as you file, the second you file, there's something called an automatic stay that comes into effect. This automatic stay stops the litigation all across the country in its tracks, and it stayed. Parties can file a motion to lift the automatic stay. Usually that is not granted, at least not initially. Now what happens is, a lot of times these litigations are not only against the actual defendant, which files for bankruptcy, but it's also against officers, directors, parent companies, sister companies, et cetera, et cetera. The debtor will often file a motion to extend the stay to those other parties so that the litigation can't go forward against those other parties, because if they do go forward against those other parties, the theory is you're not really getting the benefit of the stay, because the other parties are still litigating all across the country. Those other parties are often the officers, directors, or parents of the debtor company and are needed to focus on the bankruptcy and restructuring the bankruptcy. Those other parties are also potentially providers of money to creditors, and if the debtor, and if the litigation goes forward against them, then it will be raised to the courthouse against them, and that will hurt the debtor. In most cases, up until recently, it was a no-brainer. The stay would have been extended to those other non-debtor third parties. It happened in Purdue. A whole bunch of AGs who were suing Purdue were so upset. Actual AGs personally showed up to the bankruptcy court in front of Judge Drain and argued against extending the automatic stay to them. They even argued that the bankruptcy court didn't have jurisdiction against them. Judge Drain would hear none of it and extended the stay against all of them. When J&J and when LTL initially filed for bankruptcy, the stay was extended to J&J. That was the first time they filed bankruptcy. They filed bankruptcy a second time. They may file a third time. Who knows? Maybe a fourth time. In the Arrow case, judges started to get a little skeptical of these extending the automatic stay to parties who did not file for bankruptcy. And I believe, David, correct me if I'm wrong, the judge did not extend the stay to third parties in the Arrow case.
Correct.
And that kind of threw a wrench into the idea that we can just file for bankruptcy and get this breathing room that we need. Now we don't know whether if you file for bankruptcy, you'll get the breathing room, because I think, frankly, because of the Purdue case, bankruptcy, which is an excellent tool for resolving cases, got kind of a bad rap. And also because of the J&J case where they did what's called the Texas two-step. I'll let David talk about the Texas two-step. But basically in Texas, for some reason, I don't understand how that's possible, but you can just create a new company and give that company all the liabilities and you keep all the assets. I mean, imagine if I could do that in my personal life. Create a company. That company has to pay my mortgage. That company has
Sounds
to
like
pay
a good deal, Ed. Maybe we should all, Texas has a divisive merger statute that it allows the, can I just ask you, Ed or David, so when you file for bankruptcy, you have the automatic stay and the extension that you mentioned, but there's also other processes. There's a, just to kind of give an overview, there's an estimation process, which can be kind of contentious and difficult. And there is a proof of claim process that applies in some cases, not all. And then there's a voting process. It's like, I think Ed, you mentioned this before, which is very different from proceeding in a class action or a MDL, although some of those things might have to be part of the litigation. So could you just briefly touch that? And then I really think we need to get into the Purdue.
Let me roll on that. I mean, in a bankruptcy, I mean, with respect to the debtor and the debtor's obligations, there's a bar date notice. There's an internal bankruptcy statute of limitations. Normally, it sometimes doesn't happen in mass tort cases. There'll be notice, sufficient constitutional notice, so people can say, I'm going to participate in this bankruptcy. If they don't participate in the bankruptcy by the bar date, then they don't have a right to any of the debtor's assets. This is a way to cut off claims and to aggregate everything in the bankruptcy court. If there are issues as to how much your claim is worth, and there's issues as to that. Now that's easy when you're presenting a bill for 100 widgets. It's not as easy when you say you've got to claim PFAS liability, water provider. What is the damages for that? Bankruptcy courts can, without adjudicating the merits of an individual claim, estimate what that claim may be worth for the purpose of going forward. And the goal of a bankruptcy is consensual negotiation by the creditors with the debtor to arrive at a plan, which is a contract, for the distribution of the debtor's assets. And there's lots of devices within a bankruptcy to deal with that. But I'm going to segue now to what you're talking about, Deborah, because all of that, when you introduce the concept of third parties, gets very complicated. And one of the things you've seen, and I agree with Ed Niger completely, bankruptcy is a magnificent tool to resolve mass tort claims. But tool means everybody's discussing together and coming up with a fair and equitable solution. More so lately, which is where you've seen the pushback that Ed has talked about, not only from the courts, but from the creditor claimant community, is that defendants started using bankruptcy as a weapon to cram down mass tort claims involuntarily. And so to the extent that the tool of these non-consensual releases, when in partnership with the tort claimant community, can be used to get settlements beyond which you could get in the normal course. Boy Scouts, 2.5 billion historic sexual abuse compensation fund. Sometimes they've been used, and this
David
is
has been instrumental in that. Thank you, David.
yes, and it's used to cram down tort claims non-consensually. And the issue in Purdue, Edward Niger said, well, Judge Drain extended the stay. Well, the issue of the stay extension wasn't against Purdue. Purdue has a right to an automatic stay. It was the state's claims against the Sacklers. The Sacklers, okay? So all of a sudden, you have a political overview, you have an optical overview, you have a public relations overview, and you've got, you know, people who have been identified by some people out in the public as being very serious wrongdoers, and I'm being conservative in what people have said about them. But in any event, that's where the pushback comes, is when you're trying, and the Sacklers took $12 billion out of Purdue from 2007 onwards and placed it all over the world. And so the bottom line, and when you look at the other bankruptcies that we're going to go through, whether it be Texas two-step or PFAS, derivative claims, or, you know, PFAS, there's, Deborah just mentioned PFAS, AFFF liability, Forever Chemicals. The first company called Kitty, KFI, which you see on your fire alarms, filed for bankruptcy. Kitty is a subsidiary of Carrier, a very solvent, mighty US corporation. And the question is Carrier going to get its liability resolved in that bankruptcy? So really the golden thread of all the major issues, and this goes, you can see it on the outline, is basically using bankruptcy to resolve and address the mass tort liability, not necessarily only of the debtor, but of solvent third-party creditors, third parties.
Just one point that I think you guys can respond to, because the other component of bankruptcy, and it's mentioned on the outline, is a way to deal with future claims, and that has always been a very difficult component of a class action device. In a MDL or mass, you know, some sort of consolidation, you can try to account for that, but there is a mechanism, a channeling injunction mechanism in the bankruptcy process, and maybe you could just touch on that for a second, because that's a different benefit.
Sure. One of the great benefits of bankruptcy is, unlike with class actions, unlike with mass tort settlements and MDLs, bankruptcy can resolve future claims. It appoints and this arose out of the mesothelioma asbestos cases, where it's codified that there will be a future claims rep who acts basically as a guardian ad litem for future claimants who don't yet exist, under guardian ad litem fiduciary obligations, will come in and structure within the bankruptcy plan, along with the current claimants, a solution for the future claimants. And the golden thread rule on that is the futures need to be treated in the same way as the current claimants. So to the extent that there's a fund created that pays everybody 75% of that claim, there needs to be an assessment of what the extent of the future claimants will be, and you're going to have to reserve an amount of that fund in order to pay the future claimants the same pro rata rate as the current claimants get. So bankruptcy does offer that to future claimants in a way that, to the resolution of future claims in a way that neither mass tort settlements or class actions can do so. Deborah?
Maybe you could.
And I think that,
Oh, I'm sorry. I just wanted to say maybe we should talk about what the issues are in front of the Supreme Court right now, because I think, Ed, you mentioned, one of you mentioned, we're going to see a decision by June because that's the end of the term. And so, but there, you know, what are those issues? Because they will have, or could, the decision there can have an effect on a lot of other cases. So
the single issue in Purdue is whether the bankruptcy code allows the bankruptcy court with the various parties in the bankruptcy to construct a plan, as I told you, for the payment to all the claimants that will involve what Ed has described as non-consensual, non-debtor releases, meaning that if enough people vote in favor of this treatment, this plan, and the party that gets the third-party release, the non-debtor release, contributes enough money that the court views it as substantial enough contribution, and the case is unique enough, notwithstanding that not every tort claimant has agreed to release his, her, or its claim against the potentially released third party, if enough people vote and the criteria is met, that those releases will follow and provide that third party with finality. A finality that to the extent anybody sues them anywhere else, they pull up the bankruptcy plan and they go and join that claim. The court is hearing that issue. The heard argument, as Ed said, on the 4th. We can all surmise, it deals with the Sackler releases. So that public relations, political overlay is there as well. I think the general consensus from those who understand the issue, although you never know what the Supreme Court will do, is if it's the over-under, is that, people think more likely than not the court is going to do something to mitigate or circumscribe either entirely or somewhat the ability of bankruptcy courts to utilize this tool, and it is a tool when used appropriate, to package these centralized settlements that provide the participating parties with finality and also allow those parties to provide substantial contribution that can then be used to pay the claimants. Ed?
Yeah, I think your over-under is correct, although not in the way we predicted. We thought that it would be the conservative judges who are against it, because essentially you're reading something into the bankruptcy code that is not explicitly stated, and the conservative judges are very textualist. And we thought that the liberal judges would be for it. And that's really how it split in the Second Circuit, although everyone in the second, all 3 justices in the Second Circuit were for it. There was one reluctant concurrence, which in my opinion was even worse than a dissent, and that was by Judge Wesley, who was a conservative judge. And then the 2 liberal justices, Judge Newman and Judge Lee, were very much for the non-consensual third-party releases. So we thought it would play out that way in the Supreme Court. Well, the Supreme Court, you have Justice Kavanaugh, who is a very, very strict constructionalist, was totally for non-consensual third-party releases. It's like we have 30 years of precedent doing these non-consensual releases. Everyone agrees to it. Why does the U.S. trustee and the DOJ even think they have standing to go against the plan that everyone wants? And then you had Justice Jackson, who really is very much the same ilk as Justice Lee from the Second Circuit. They were both public defenders. They were both on President Biden's short list to be placed to the Supreme Court. They're both very liberal ideologues. And she was so against it. She was like, well, I know it's necessary for the plan, but isn't that just because the Sacklers raided the company? I mean, she said something to the effect of, even if I would agree that in some crazy circumstance, non-consensual third parties are okay, wouldn't this be the one case where they're not okay? So I agree with the over and under of David Moulton that the Supreme Court will do away with it. But it was really surprising that our prediction on how the justices would fall did not turn out to be correct. It did not fall along party lines. I just lost myself on camera. Oh, we're doing
Okay.
the poll.
It wasn't a red state, blue state issue, so to say. And you had also Neil Gorsuch, Justice Gorsuch, going beyond the statutory issue and actually raising the issue of whether these non-consensual releases, even in the context of an asbestos 524G plan, which is in the code, violate constitutional due process by
Yeah,
taking
I
property.
thought that was totally unfair of him because that was not the question that the Supreme Court asked. The Supreme Court asked us to brief whether these releases are allowed by the Bankruptcy Code.
Right.
He like kind of, threw us for a loop. Good. I'm very happy with his results. They're very
Well,
fair
in
and
any
very.
event, we'll know, but some of the other things that are going on in the bankruptcy courts, as you have read, and I've been very involved in, is the Texas two-step, and that's the divisive merger. And J&J suffered 2 dismissals in the span of a year of 2 bankruptcies based on their use of the two-step and how they structured it. And the Arrow case, the 3M earplug case that tried to do a bankruptcy, claiming they needed a bankruptcy to get to the settlement with these veterans with hearing loss, claimed hearing loss as a result of the earplugs, also had their case thrown last year, 2023, which was I wouldn't call it a pure two-step. It was kind of along the lines of that, but wasn't purely a two-step, but had their cases thrown where the affiliate was trying to use bankruptcy to wash the liability of 3M, the parent. And guess what happened after that bankruptcy was dismissed? They went back to the MDL, and I'm looking at you, Deborah, and they settled the case in the MDL without a bankruptcy. So, that's an important point. And one of the things we are seeing, and this is the Whitaker Clark Daniels case in New Jersey, which is a mesothelioma asbestos case. And there are other cases as well that, seeing that Purdue may be turned upside down and that non-debtor third-party releases may be outlawed. Debtors going into bankruptcy are jumping on the wagon that all the claims that a plaintiff may have against successors and parents and others may be derivative claims, and that I could spend an hour talking about that, but a derivative claim, a successor liability claim, for example, which is under the case law of various circuits, once you go into bankruptcy, the property of the estate, which the company can settle with its parent without plaintiff consent. So these are issues going forward and beyond. And actually looking forward, one of the things that we in the bankruptcy bar like to believe is that we're very creative and nimble. And with people like Ed Niger and others, we are. And the bottom line is if Purdue goes the way that most people think, and that the Second Circuit is reversed, and that this tool that's been in our quiver or toolbox is gone, there are other ways to skin the cat. They may be harder, they may be less convenient, but to the extent that we need to put together architecture that allows third parties to join a bankruptcy settlement and achieve now what I call, in the absence of Purdue, relative finality as opposed to unequivocal finality by way of a non-debtor release. There are ways of doing that using analogs we have, and I'm looking at Roy, from class actions, such as you have opt-outs there. Here you can opt into consensual releases. You can make the plan so attractive that most people won't go out of the plan and pursue the non-debtors. And so there are ways that we're devising to deal with the fact that the non-debtor, non-consensual release may not be available subsequent to June 30th, and go forward with continuing to use bankruptcy to solve, and as a tool, not a weapon, but as a tool to solve mass tort liabilities. And again, one of the greatest benefits of that, as Deborah was so keen to point out, is the ability to resolve future claims in those plans.
Thank you.
Well, I hope the Supreme Court wasn't listening to you, David.
Well, listen, we argued strenuously, as you did, your people did, for the Second Circuit to be upheld. And it was nice to hear Judge Kavanaugh make that speech about precedent, by the way.
Great.
So I think we have reached the end of our hour. I know that there were some questions that were raised during the course of this presentation that we didn't get to. I believe there's a procedure for us to respond afterwards to questions. I'll ask Dan or Aaron to confirm that, but I just want to thank all the panelists for this engaging discussion, and you can see it's the tip of the iceberg. So there are many, many things to talk about here. So thank you all very much.
Thank you, Deborah. Thank you, Deborah.
Thank you,
And yes, we will be sending those questions onto the panel, so rest assured they will be in touch with you. But yes, thank you very much for that incredibly insightful discussion. We really appreciate your time. Edward, David, Roy, and of course, Deborah, thank you very much. We have a lovely rest of your day, and thank you to our audience. Hope you all have a lovely rest of your day too. Goodbye.
Thank you. Bye-bye.